Hello. Good evening, everyone, and welcome to today's webinar on DPDP 2025, the future of compliance, what every business must know. I am Charan, and I'll be your host for today. So we are delighted to have you, each one of you, join us as we explore one of the most important regulatory changes impacting the Indian business today. We'll wait for another minute as more participants to join in. While we do that, feel free to drop in chat what you're hoping to learn today or your thoughts on DPDP. We'd love to hear your expectations. Yeah, thank you for waiting. Let's get started. The DPDP Act is India's new data protection law governing how personal data must be collected, used, and safeguarded. Yeah. With the DPDP rules officially notified in November 2025, the implementation phase has truly begun, and organizations now need to gear up for the phased compliance rollout. In today's session, we'll give you a clear understanding of the DPDP rules 2025, what they mean for organizations, the practical challenges you should prepare for, and how technology can support your compliance journey. We'll also have the Q&A towards the end. So if anyone has any queries, you can feel free to drop in the chat box. A small intro about Ricago. Ricago is a GRC company started in 2014, helping organizations to mitigate the non-compliance risks with our technology platforms and services. As on date, Ricago is serving more than 250 plus enterprise clients with an active 10,000 plus users on the platform in streamlining the compliances. On that note, I'll introduce our speaker for today. Today's speaker is Mr. Govinda Chandrapatra, a seasoned compliance and security expert with over 25 plus years of experience. He holds certifications like CISA, CISM, CRISC, and is a DPO certified by ISACA. He has worked with leading organizations such as NAL, and cross-domain solutions, and now heads ISIT consultants specializing in compliance standards and security audits. With that, I'd like to invite Mr. Govinda to take over the session.
Good evening, everyone. Good evening, everyone. Welcome to the session. Thanks for joining, taking out the time and joining the session. So let's talk about, we have discussed last two sessions with what is DPDP and all. Let's go a little bit into that and understand what is the purpose and scope of DPDPA with the new rules coming in. So basically, DPDP Act aims to provide a statutory framework to protect individuals' data principles, which is called data principles, and to regulate organizations, data fiduciaries, and data processors handling the data of the individuals. Right. So broadly applies to any processing of digital personal data of individuals in India. This is specifically for India, any company who is there in India and sending data abroad also will be applicable for them. So we'll get into more detail on that. So based on facts like volume and sensitivity of data handled or potential impact, some entities may be classified as significant data fiduciary. So based on the sensitivity of the data, what is handled by the organization, it will be defined as a significant data fiduciary, which comes with the additional obligations to be implemented. So in this makes DPDPA relevant to a wide range of sectors: IT, SaaS products, software as a service, e-commerce, fintech, online platforms, health and education, and more. So if I talk about, it will be almost like all the organizations which is there in India, somewhere or the other, it will be applicable. So recent key update is on 13 November 2025, the official Digital Personal Data Protection Rule 2025 was notified. That means the implementation will start, and slowly with the deadlines, whatever is set by the government, we will have to implement and make sure that we are compliant to that. So these are the dates what the government has declared, right? So first is the forming the DPB, which is the Data Protection Board of India, which will be done by the government, which is the November 13, 2025. It's already done. Immediately, the government has notified who are the board members, who are the part of the Data Protection Board. Okay. Then the second timeline is on the consent. Okay. So if you want to add somebody as a consent manager by a third party, or you want to implement internally, by November 13th, 2026, you have to have a consent manager, whether it is third party or internal. Then finally, the final implementation will be by March 13, 2027. After that, any breach or any kind of personal data is leaked, the organization will be liable, and they have to notify to the DPB, which is the Data Protection Board, and legal action will be taken on that based on the outcome of that. So DPB will be the final authority in DPDPA Act who will decide what action has to be taken. So the key compliance and best practices which we will have to implement now, right? So one is on the organizations, including startup, SME, large enterprises, everybody, they have to have a consent and notice management. If there is a breach, how do you inform that? How do you notify the DPB? How do you notify the individuals? So these two has to be there, which is an immediate implementation, right? And then the data principal rights handling the data. So what are the rights of the data principals also has to be defined, documented, and implemented. So which are the systems, processes to support users, request for access, correction, erase, portability, and grievance redressal system has to be implemented in the company. The best practices which has to be brought in place again is on the security safeguard and data governance, implementation of reasonable security safeguard, that is a mandatory thing. The organization has to take a reasonable security safeguards like encryption, tokenization, access control, logging and monitoring, data backup, secure deletion, retention control, audit trial. This has to be put in place. Whether we are processing or we are giving the data to be processed by a sub-processor, both will be liable for that to implement the security and safeguard of the data governance, right? So then coming to breach notification and incident response, if there is a breach, we come to know about that. Then how do you communicate? How do you notify the individual whose data is breached? And you communicate with the DPB. And how do you react to the incident whenever it happens? How do you react to the incident? Also has to be documented and followed with timeline. Okay. So then coming to the consent manager and the governance setup, if applicable, if you are consent manager, you are hiring somebody as a third party consent manager service, then you have to make sure that it is registered with the DPB and then meet technical and operational requirement and integrate cleanly with your data collection and consent flow. So whenever you are collecting data, whatever flow is there in the collection of the data, you have to have a proper consent management to be built into the data flow. Then it is also applicable whenever you send the data. So this is basically applicable to all the companies who are there in India. But if you are there in India, but your parent company is there in US or outside of India or any other countries. So in that scenario, so if you are sending the data to the cross-border data transfer, what is to be followed? How do you make sure? How do you make sure that data is safe, right? And you should be actually there will be a guideline from the DPB in which all countries you can send the data because permitted jurisdiction will come into DPD by the guideline. Okay. So documentation, audit and governance readiness, you have to do or internal audits or third-party audits to make sure that you are compliant to the DPDPA and then submit report to the to the board and then document what is required, what are the impact assessment, you have to do access log, consent log, everything has to be captured and kept with you for review and storage for in case of any incident. So important here to keep in mind that for many organizations, compliance under DPDPA may require technical changes because your application may not have the consent mechanism. So it has to be a data architecture may change. The consent flow may have to be built into the system. Logging and encryption may not be there. So that also you have to build into the system now. Policy update and process reengineering has to be part of that. So these are the important things which you have to keep in mind when you are looking at the DPDP Act. These are some of the challenges which we feel that you may face when you are doing it, right? So the first thing is the criteria for designated significant data fiduciary remains somewhat vague in the rule, right? So who is significant data fiduciary? Whom you can say? Because I may feel that the data what I'm capturing is not that critical, but for the DPB it may be critical. Then how do I define it? How do I self-assess that? Okay, whether I fall into significant data fiduciary or not? That's a challenge, right? Today the rule doesn't say very clearly how do you define it. The rules adapt a one size fits all. It is actually the same rule for breach notification, whether it is a small organization, it's a big organization, any incident or minor incident or serious incident, it talks about only penalty, the same for everybody. So it cannot be like one size fits all. And for the incident, which is like defining that what is minor, major, and all that. So that's a challenge again. The next challenge is on the data collected before the act has come up, right? So today it is on 13th November, has come as a rule. So now if I look at what happens, the data what I have already collected. Okay. So whether I have to go back to the individual and say that, okay, you have to give me a consent. If they don't give a consent, I have to delete the data or I have to what to do with that. So the rule is very silent on that. Today, we actually don't know what is to be done for the data which is collected before the act has come. So we will have to say, wait and look at that, what to be done. And smaller organizations and startups may struggle with the resource burden because you have to have an audit, data governance mechanism, and data protection impact assessment. You have to do it, record keeping, and all. Smaller organizations may struggle with resource, whether they can get it with the affordability. All that will come into picture. And the last is the rapid evolving sectors, right? AI, analytics, and all, and cross-border operations. How it will actually look impact the AI related projects or AI related companies or wherever you are doing analysis of the data. You have huge data. If you look at AI, right? AI has got access to all the data what is there in an organization because it has to read from there and then understand the how it has to behave, right? So that's again a challenge, how it will work in the future. So these are the some of the things which is actually is still not clear. Hoping that government will come out with some clarification on this point. So maybe we will have to look at it at some point of time later. So looking at that, so what it means for us, any organization which is based in India, if your organization collects, processes personal data digitally, users registration log, analytics, customer data, etc. You must start planning now. Full enforcement will come by May 2027. So by that time, you have to implement fully. Consent and all by November 2026 and then May 2027, it has to be fully implemented. Non-compliant could lead a significant financial penalties and reputational damage. Financial penalties, it's there down, but it goes up to 250 crores. So that's a big amount for any company. Adopting robust data governance, privacy by design. So anything you implement today, any application you want to implement today, you have to look at what is the data governance. If you're collecting in that application personal information, how it is designed. You have to evaluate that. If you want to use a third-party product which is available in market, so you have to, before using, you have to look at how is the privacy by design it is implemented and evaluate the product and say that, okay, and the consent also mechanism, how it is there, whether simple example, HR product. Today, they don't take a consent in the HR product. Now, every organization has to inbuilt and say that my product will take a consent whenever you go and tell the into the candidate or employee or somebody to give the data. First, has to take the consent. So that is how it will work now. So it has to be implemented across organizations. So if you handle large volume of data or sensitive data, right, which is related to health, financial identifiers, or operate across border, your compliance effort will need to be more rigorous because one is the data is going out of your control because when it is goes out of the country, legal implications are more actually in that because you cannot go fight there. Their rules will come into picture. So you have to take more effort to and more rigorously you have to implement the security requirements. So then how do we do it? How do we implement now, right? So there are Seven, eight steps are there, pages are there, which we should start and then do it. So I have defined here like phase one, which is assessment and planning. That is the first phase. You start doing the phase one now, assessments and planning. So what you will do, identify the personal data collected, what you are processing, where you are storing, and said, okay, and map data flow across systems, because if you have multiple systems, how the data is flowing, you may be collecting in one place but using in another application that data. So map all the data. So once you do all this activity, like identify the gap and against the DPDP requirement and all, you do that. Then the deliverables for that should be a data inventory and data flow map, which will come, gap assessment report and compliance project plan, what we want to implement. So responsibility team will be compliance, IT, security, and legal, which is the team which will do the compliance assessment and planning. Timeline will be around 2 to 4 weeks, which is required for depending on the size of the organization and the data you are collecting. It will take 2 to 4 weeks. Phase two is basically consent and notice framework. You define your create and update your privacy policies, whatever is there. Define it, update it, right? So that and communicate to people saying that this is our new privacy policy, this is our consent mechanism, specifically defined wherever it is required. And integrate with the consent manager if it is a third party, which is optional. There are some criteria where you have to have a consent manager third party. So if required, you can have it and integrate them to your system so that it is easy for you to do it. So the deliverables will be update privacy notice, consent architecture document, consent logs, and user interface change, right? Because consent log, if I give a consent today, it has to be stored into the database. Tomorrow somebody comes back saying that, no, no, I have not given consent for this. Then you have to showcase that, okay, this is the log and this day, this time, even we have to go to the time level saying that this time it was done, right? So responsibility will be product team, legal, engineering, or any third party you are using the application. They also will be responsible for that. Okay. This may take around 4 to 6 weeks, depending on, or more than that, depending on the product what you are using. Because some products may have a bigger impact when you change the architecture, and also it may take more time on that. Phase three, basically user rights management. You have to implement encryption, you give access control, you have to, anybody access the data, you have to log that, you have to log it, saying that this person accessed on this day, change the data on this was changed from this to this, all that information has to be logged. And then define the data retention and deletion policy, how many days we will keep it, when we will delete, how we will delete it, right? Ensure secure processing by vendor and processors if it is outsourced like payroll. Generally, we outsource in organization. If that is the case, then how do you actually, the vendor will actually process it securely. So that we will have to define it. And then conduct VAPTs, vulnerability assessment and penetration testing on your network, your application, and all that. So the deliverables for that is user rights SOP. You can define SOP saying that this is how things will work. Then grievance redressal mechanism. You have to have a grievance redressal mechanism and it has to be communicated. The end user whose data you are collecting should know that how I can get, if there is a grievance, how do I reach out? How do I do it? How do I communicate? And who will respond that? What is the timeline for the mechanism? So all that has to come into picture. And then request handling, log and tracker. You have to, if somebody has given a grievance or anything, you have to log it and track it. This will be done by customer support or IT or legal or DPO, whomever is supposed to do it. This may take around, implementation may take around 3 to 4 weeks. That's what we feel. So phase four is basically the technical stuff, basically the security and technical controls to be put into the application, right? Establish processes for access, correction, erase, and grievance addressal. So in the application itself, you have to build in saying that the end user can actually request that this data is wrong of mine. You have to update it. Like for example, address. People keep on changing mobile number. People change it. So there should be a clear process to be there in the application itself, which can actually help me to do it. Okay. Implement request handling database, data boards or workflows. Okay. Wherever the request has to come, how the workflow will work, who will do what has to be very well defined in the policy. And then train internal team on handling the data principal request. If somebody is doing it, because see, only DPO cannot do it. So you will have a team to handle the things, data update and all that. So that you do it, train to the team how they have to do it whenever there is a request coming in. So for this, the deliverables will be security policy pack, data retention and disposable policy, vendor risk assessment report and VAPT report, technical stuff, right? So it has to be responsibility will be by IT, security, engineering, and DevOps. This may take 6 to 10 weeks because this is a technical implementation, will take a longer period for doing it. So coming to phase 5, which is the breach management and reporting. If there is a breach happens, then how do you do it, right? Establish breach detection and response procedure. Define the procedure. Define internal reporting and escalation metrics. If something happens, who will talk about what? Because it should not happen that everybody goes to public and tells that, oh, we had something like this. So somebody is defined in the organization who can go to media or who can actually announce to public. Otherwise, it has to be kept internal, right? And create a DPDP compliance breach notification template itself that, okay, how somebody, if there is a breach, how somebody can report. So that is where it will actually help you to put the process in place. So deliverables will be the incident response plan, breach notification template, and incident register. And you test it, whether it is working or not in a particular frequency, maybe 6 months, 1 year after you implement, you test it out, telling that if you create a scenario that, okay, some breach has happened and then the plan is working or not. So in actual scenario, you will have that, okay, it is working or not, okay. The responsibility team is security, compliance, and legal on this. So timeline is around 2 to 3 weeks, okay. Then the phase 6, which is governance, documentation, and training, right? So create, update privacy policy, SOPs, compliance logs. Some of them will come from the previous pages already we have documented, and any other documentation has to be done, has to be documented here. And assign data protection officer. We will require a data protection officer for this. Each of the organization may not be internal. You can have also virtual data protection officers because small companies, they will not be able to and define somebody like dedicated resource, right? So then you can have virtual. Establish monitoring, internal audits and review cycle. You have to have internal audits for DPDPA, publish the reports, right? And review the cycle, and then conduct awareness training and program, like how we are doing security training to employees, right? Whenever they join, or the policies, whatever you have, leave policy and all that. DPDPA also will come into picture saying that you have to give training to all your employees on the data protection, how to be done, what is to be done, what data they can share, with whom they can share and all that. That has to be trained to all the employees. Deliverables, DPDP governance framework, roles and responsibility metrics, training records, audit and review reports. This will be mainly with HR, compliance and legal department who will have to implement that. This will be ongoing job because it's not one time you do it and then say that, oh, okay, everybody have trained, but people keep on joining, leaving and all that, right? So then you will have, it's an ongoing job which you have to do it. Then finally, the phase 7, which is the continuous monitoring and audit, right? So once you implement everything, you have to make sure that monitor that it is working as per the plan. So what you do is you put a process in place where say that, okay, I will do a quarterly compliance monitoring or a quarterly yearly internal audit and understand that whether specific audits for DPDPA. It's not that you have other audits you combine with that and all. This has to be specific DPDPA internal audits and monitoring, compliance monitoring. Review the consent flows, whether it is working as per the need, because sometimes consent flow, maybe you are taking more information, but you have mentioned in the consent saying that only few things, right? So I'll give example. We collect so much of data, but we are in the consent, we are not telling that I will share your data with the BGP vendor. Okay, sometimes we may share the data with the insurance person. So we will have to mention today across telling that I'm collecting your data and this will be actually given to say BGP vendor. I will share it with your insurance. I will share it with your travel agents if you are providing a travel tickets and all. So that specific consent has to come. So that's why you have to keep on reviewing and understand that it is as per the requirement what we are doing. Okay. Then the deliverables will be quarterly compliance checklist, annual audit reports, and update risk register because wherever there is a risk has to be registered and the mitigation has to be done for the risk. The responsibility team will be compliance, security, internal audit team, and it is an ongoing process. It cannot be one-time activity, right? So basically, these are the 7 steps pages what we will have to go through to make sure that we are compliant to the DPDP rule by 2027 May. Okay, that's how it will be. And then coming to the penalties, they have earlier they declared that the maximum penalty will be 250 crores straightforward for any incident, but they have actually come out with different levels of penalty, but maximum is 50 crores. So 250 crores is basically failure to implement reasonable security safeguard to prevent personal data. If it is proven, if there is a data breach and it is proven that there was no security safeguard, then it is 250 crores, which comes under section 8.8 and 5. Okay. And failure to notify board and affected data principle of personal data breach. If there's a data breach happens, you have not informed the person and the data protection board, then it is 200 crores. So that's how it is, right? So the section is 8.6 in that case. Okay. Non-compliance with children's data protection obligation. So because we cannot use children's data as such unless until you have taken a consent from the parents. So if you are still using it, then it will come under section 9, again 200 crores. Okay. Breach of significant data fiduciary additional obligations. If we have taken for some purpose, but we have used for some other purpose, in that scenario and there is a breach happens, then in that case, section 10, 150 crores. Okay. And breach of data principal duties, false information, if you have given, when there is a data breach happens or to the data principal, you have given wrong information, in that scenario, it is 10,000 rupees. Okay. Which comes under section 15. This is the smallest one. Okay. Failure to comply with voluntary undertaking acceptance by board, which is as per the original breach is 250 crores. So that is what will happen. But section 32. Other breach of act provisions or rules, general, if it is general, some data breach happens, you have put some controls, but there are some leakage because of certain failure in the system or something, it will be 50 crores. So this is the kind of penalty what you have to pay when there is a data breach happens due to the different category what we have, the amount will differ in that. So when we want to implement it, what are the real world challenges, right? So that's what will uh, actually put us into trouble, saying that these are my challenges. How do I do it? How do I make sure that I follow the DPDP Act? So first challenge is set up the governance. If it is a small organization, you don't know who all will required in the governance. How do I do it and all that? Data mapping, because you are collecting some data, some systems, third party, you don't know what data they are collecting it. So how do you map it? If I don't know the data, how do I map it? And if I ask the third party, he has to give all the information. If they don't give it, then I'm actually failing in that. So that is again a real world implementation challenge. Readiness gap assessment, somebody has to do it. That's again a challenge. How do you do it? What are the things which you want to do it? How do I do a gap assessment? How do I check it? What are the things I have to check? Then consent and notices, notice fixes. How do I implement the consent mechanism and the notice when there is a breach? Policy and SOPs, not everybody can write a policy and process, then you have to depend on somebody else to get it. Then the security enhancements, because that involves a cost again. You have to get the cost approved by the board, your CEO and management, then it becomes a challenge again for security enhancement. But now with DPDP, I'm hoping that you will get all the approvals for security implementation, right? So then the vendor contracts and controls, whenever you are have a vendor where you are sharing your personal the PII data and all, then what you do it, okay? Enable user rights, you have to control it. If it is a different location, different country kind of scenario of a company, it is very difficult to understand who will have access, what kind of access, and all that will happen is a problem. Then breach response setup. So somebody has to understand that, okay, there is a breach happened, then what is the response, who will respond and all that. That will become a challenge again. Training to all the employees, if it's a bigger organization, training itself will take 1 month, 2 months, right? Because you have to have a process in place and application to be there in place. Then audit and continuous compliance, then somebody has to be there to audit internally. You may not have somebody to do the audit, right? So that's how it is. So these are the real world implementation challenges organizations going to face, whether it is small, medium, large. So that's a challenge, but we will have to implement. There is no choice for us. Otherwise, the previous slide will come to picture, right? Penalties. So that's how it will work. Okay. So let me put some myths and facts how people understand today, right? So companies can collect any data without limit. That is actually a myth. You have to have a consent and lawful purpose. You have to communicate that and do it. Data can be kept forever after consent. That is also wrong. Data must be deleted once the purpose is fulfilled. And DPDP applies only to big organizations. And that is actually, I told you, it is applicable to everybody who is collecting personal information. Ideally, it will be for everybody because as a HR, you will be collecting the employees' personal information anyway, right? Then you have government cannot access personal data. That is also wrong. There are exemptions for security and law enforcement. They can actually ask you the data. In that scenario, you will have to share the data with them. DPDP gives full GDPR style erasure rights. Actually, no. It depends on how we collect the data. When collecting the data, what is that we are doing it? Okay. GDPR is different, and DPDP has a different understanding. So that's how it will work. Children's data is handled like adults. That is also wrong. You need to have a parent consent for that. You have to take a consent for the children's data to be used. DPDP blocks all data sharing. That is wrong. You can actually sharing based on the consent. Like how I told you that, okay, if I need to do a BGP, right, I need to share it with other companies. Only breaches attract penalties. No, penalties apply for multiple violation also. Okay. Offline only data is covered. This is only digital data, not offline data. Today, the DPDP Act talks about only digital data. If it is offline, they don't talk about that, what will happen. So that's again one challenge, how to do it. The government is assuming that everybody has digitized the data, which is in India is not correct actually. So that challenge. So we'll have to see that if it is hard copy, then how do we handle it? Freely available online data can be used without consent, which is not correct. If it is publicly available also, you cannot use it for your process. Like for example, you want to use it for your AI to learn something or something like that, you cannot use it. In that, because you are using for a specific purpose, then you have to take a consent from the individuals. Cross-border transfers are banned. It's not actually cross-border transfers, you can do it, but you have to make sure that security is taken care. The uh, data is controlled when it is encryption is there at rest, encryption is in transit. So all that security features are built into the data. So these are some of the myths and facts. I'm any questions or anything, I'll be able to answer on that if it is there. Yeah.
Yeah. Whatever. Not that. Yeah. Thank you so much, Mr. Govinda, for the clear and insightful explanation. So as highlighted, DPDP compliance today goes far beyond the policy updates. It requires structured governance, documented process, consent management, breach readiness, vendor oversights, continuous monitoring, and much more. This is exactly where Ricago Compliance Management System can help. Ricago is an integrated governance, risk, and compliance platform used by 250 plus enterprise clients as on date. Ricago offers a comprehensive compliance library with 1500 plus acts and real-time regulatory updates, which includes all your DPDP related acts, labor codes, everything. It has a 4-level maker-checker workflow for collaboration. It automates all your alerts, notifications, dashboards, reports, and it also acts as a secure document repository. Also, Ricago is hosted on Microsoft Azure. We are ISO 27001 certified, SOC 2 certified, and are also VAPT tested. So, as organizations prepare for the full enforcement deadline in 2027, smart tech enabled compliance management isn't just helpful, it is essential. With that note, we'll open the floor for the Q&A. Please type your question answers in the chat box. We'll take them one by one. So, yeah. So we have already collected a few questions from the chat box. So the first question is, what actions are required to be initiated at a company's data fiduciary, and to fully comply with DPDP Act?
Yes, the first thing is to be done is collect the personal information, whatever you are collecting, the document it and say that, okay, these are the personal data what you are collecting in the organization. Then you map it whether what purpose you are collecting or not, and then take a consent. That is minimum what we have to start with.
Okay. So what about if we are getting data from abroad for processing?
So see, DPDP is applicable to the data which is of Indian people. So if you are collecting some data from abroad, outsiders, then it will not be applicable.
But the data is being processed.
That is still fine, but this is applicable only to Indian data.
Okay.
GDPR is European.
So again, moving on to the next question. Who is required to appoint consent manager? Every data fiduciary, SDF, or any specific class of data fiduciary?
Yeah, there is actually a definition for that, telling that who requires to, and it's also, again, it's not mandatory. You can have your own internal consent manager. Third party is actually, you can decide. If it is a bigger organization, you don't know how to do it, then you can actually take third parties help to do it. So it's not mandatory.
Okay, I think there's an add-on question there. If we are managing the consent in-house, do we need to register ourselves as consent manager with DPP?
No, not really.
Next question. Any new amendments happened in the DPDP Act before the recent notification from the government?
No. The act, see, act is same. Only the implementation standards have been declared now. That's why it has become as a rule. Act is same. There is no change in act.
Okay. Under DPDP, we need to notify both individuals and the board for even a minor breach.
Yes. If the personal data is breached, you have to.
But in that case, the number of cases you are getting in a given day, it will be very huge, right?
It will be. See, that is where actually the challenge will be how the DPB is handling the cases. Yeah, they should be able to, yeah, they will have an online mechanism and all that, but somebody has to investigate. So that may be a bottleneck at this point of time. We don't know how it will work. The DPB has to decide actually how to do it. But any minor also you have to communicate. There is no choice. Because if the individual whose data is leaked, if he goes and reports to DPB, then 250 crore because you have not communicated. Or sorry, 200 crore will be the penalty. That's why.
Next question. Will the self-assessment suffice or needed a third-party audit if the entity is not significant data fiduciary?
You can do self-assessment, but you should know how to do it. Otherwise, you have to take third-party help.
Is there any format for consent for obtaining personal data?
See, the DPDP rule is not defined anything. You can actually define it yourself. Specific telling that, okay, these are the how I want to collect the data, how I'm collecting it, and what purpose I will do it. That will be the basic thing. You can actually Google it and get it also consent.
Moving on to the next question. What is the criteria to have a consent manager?
See, there is a criteria, I don't recollect it actually, but on the rule it is there. I can check and share that actually. I don't remember that actually.
Can you please elaborate regarding the virtual DPO for small companies?
See, DPO is mandatory, right? The data privacy officers are mandatory in the organization. So if you don't know, because DPO has a role to play, right? So if you don't have anybody in the organization who can play that role, you can actually hire somebody like us who can actually help you in do that activity for you, DPO role for you.
Can we have any clause mapping with global standards such as ISO 27001, GDPR, CCPA,
See,
etc.?
it is almost mapped to GDPR. That's what I would say. The DPDP Act is only except that the penalties are different. Otherwise, the rules regulations are same as GDPR.
Are the penalty sections applicable as on date?
No, it will be applicable only on 2027 May.
Okay. Okay. Next question. We'll take a couple more questions. We are having a single website and single database from multiple companies, countries. Should we implement this for each location, countries?
Only for India, DPDP.
Okay. This is what is considered as personal data. I think this is question for everyone. Is mobile number a personal data?
Yes.
Is Aadhaar card is your personal data?
Yes. See, okay, let me put the definition. Okay. Any information, either individual or combination of two or more information, if you can identify a person, then it is a personal information. So mobile number is attached to me. So if you know my mobile number, you can reach out to me. Who is Govind? You can find out. Photograph with Google, you can find it today with a lens. So that also automatically becomes a PII. So definition is like this: any information individually or combination of two or more information. If you can identify a person, combination of information or the individual information becomes a PII, personal information.
Okay. Moving on to the next question. Data must be deleted once the purpose is fulfilled, but the HR keeps the data for future reference. We take a consent from employees stating that this we will save the personal information as long as company exists and will be used for official purposes.
Yes.
Is it correct?
Yes. See, HR has to, if you don't want to reference check and all, you can ask HR to delete it.
Okay.
So HR has to keep it because tomorrow something happens when you were there in the organization, right? Legally also they are bound to keep it. See, basically DPDP Act is actually exempting HR, okay, to some extent. Only condition they have put it saying that we are exempting HR because for the running the company, they will need it, but they have to make sure that they are securing the data, right? So that has to be there. So for HR, if they are keeping it, they have to keep it. Legally required, plus other like for reference check for the employees and all that also is required.
Whenever we are giving a consent to use my data, can I put a timeline like next 1 year you
No.
can use it to scale up, you can delete?
No, no.
That's
See, I'll tell you, see, if you are joining my company, okay, I've taken the data as a HR. How can you define that you delete my data after 1 year?
it need not be in the HR perspective.
Anywhere,
In general perspective.
anywhere you take it. If you are taking my data, I will tell you how many days is required to fulfill the job what I'm talking about, right? So I'm actually telling that When I'm collecting the data, I will tell you how many days I will keep it, what I will do and all that, right? But you cannot define as a data principle. That is not there.
So I think this is a question for everyone. So I'll go to multiple places. Whenever we enter into a company, shopping mall, everywhere, people will ask for your phone numbers, hotels everywhere. Like all this is covered under the new act.
Yes. So not only that, this new act, before new act only, Supreme Court had given a judgment telling that the shop or complexes you are going, market complex, right? They cannot ask you your mobile number. You have a right to tell that I will not give it. So before the DPDP Act, that is already there. That is your wish. You give it.
Okay. I think like GDPR is not an Indian context, but again, if I am a GDPR compliant, how much DPDP percentage I am covered?
See, if you are GDPR compliant, you may be around 80% compliant.
So you mean to say GDPR is big or DPDP?
No, not like that.
In Indian context.
Indian context, the DPDP has more controls to be there. Because the GDPR also came out telling that if you are using any European country's individual data, then it is applicable. Same way for DPDP.
Is there any audit requirement as per new rules?
Yes. You have to have minimum yearly audit.
Okay. For any data breach, in addition to informing DPP, are we still required to inform the certain within 6 hours?
Certain is different, so that will be there both.
Yeah. Will our government be providing more granular information on definition of significant data fiduciary?
They have to.
It is still awaited.
Yeah, they have to do it because that we cannot define that. As an individual company, how do I can say that I'm not, so how do you justify that? So the government has to give that clarification. They have to give the clarification on that. That will come. See, we have to understand one thing, right? The act has come as a rule. Good, it has come as a rule. So we have to implement it. But there will be challenges initially. That's the reason they are telling that you implement before 2027. So they have given almost like 1.5 years, right? So these challenges will come. These are the questions which will come. Then government, there is a DPP body is already formed who will look at that and come back saying that, okay, these are the problems, these are the challenges. How do we take care of that? So that will 100% will come.
If KYC is taken in a masked form, will consent be required?
Yes.
Next question. IP addresses, cookies, and personal data. This is the
Already
of the commander.
Yes. So when you are collecting from the your web page, right? You will require that.
Okay. We need a data from directors and key managerial persons in order to comply with Companies Act, SEBI, RBI.
Yes.
Still, this act is applicable?
Yes. See, there is only one more challenge is there, right? So there is no clarity, not challenge though. There is no clarity is whether this is applicable to government organization, DPDP, right? So there is no clarity now. I'm assuming that it is, but there is no clarity on that. So if you are giving your personal information to government, like IT department or the Aadhaar information and all, whether they are also bound by DPDP Act. That's one more clarification we will actually need. But I'm assuming that this is applicable across, right?
One more. How will we know we are ready for implementing DPDP Act? Is there any ready checklist to check?
Yeah, we have a checklist for that. Maybe we can circulate to the initial checklist. We can circulate that so people can fill in and do it and understand that whether they are compliant or not compliant.
Yeah. So just to add here, right? So we at Ricago are offering a free DPDP gap assessment. Our team member has already shared the form to be submitted. If you are willing to get to know at what stage your DPDP readiness is. You can feel free to submit the questions which are there on the checklist. We'll give you a DPDP readiness report based on your answers. We'll take just couple more questions. We are about to close now. The next question is, given that DPDP doesn't explicitly define reasonable security safeguards, what benchmark framework should Indian companies anchor to so their controls and standards during regulatory scrutiny?
See, it says that reasonable security is the basic minimum of access control, the basic minimum of encryption of the data at rest and transition, and who can access, how you will delete the data. These are basic things which is to be implemented, whether we like it or not, don't like it. That has to be there. So maybe some more clarity will come in the rule. So, but these are the basic things what you will have to do it.
Yeah. Are there any periodic returns to be filed to the authority?
See, they're not given that you have to file anything at this point of time. So that may be, it may come up after the implementation is done by 2027. They may say that like all other things, right? Labor department says that you file a complaint, they submit a report, your FOS committees or submit a report. Something will come like that. You do a audit and then do it. That will come.
If a company received a KYC details from the investor, will that cover further is the concern need to obtain for the existing shareholder?
See, existing shareholders, still there is no clarity because already you have collected the data. For that, government has to come back on the details. There is no clarity on that.
So shareholder can be individual and companies also.
Anything. If it is individual only, if it is company, then it will not require. If it is individuals, then you will have to do it. And there is no clarity on that, on the existing data, what is already collected. That has to be defined.
We'll take one last question. If I manage concerns in-house, do I have to register my company as concern manager with DPP?
No. You don't have to register with DPD as a concern manager unless until you are taking third party.
Okay.
If you are taking a third party support only, you have to register. Otherwise, no, don't, not required actually.
Okay. Okay. So again, we are running short of time. If any of your questions are not answered, feel free to write to us at hello@ricago.com. We'll be happy to answer your questions over the email. Also, just to reiterate, Ricago is offering a free DPDP gap assessment. The link is already shared in your chat bot. So if you want to know the readiness, you can fill in the questions which are there in the link, and we'll be sharing the DPDP readiness report. Yeah, with that, we'll conclude today's session. Thank you all for joining today's session. We hope it gave you clarity on what DPDP 2025 mean for your organization and how we can start preparing for the compliances. Thank you once again and have a great day ahead.
Thank you, guys.